don't for my car by this as like you commenting or subscribe to the channel. Godfred Odame, which is the former Attorney General, and our bell head press conference. What didn't say that to concerning in summer, Ecosia, I may say, Enkoye or Maimo, anything, the new Attorney General was Dominic Ahini, Oba, so our better advice or nya, any even 1 month and as a 2 month crowd, just with me at a cracker and go for. Now, a bino in one more case, and I'm scadi in a corruption. And then near my beer, what is 1 year, and don't you know, I say, walk for my council. Now, what you want, so I know. And I don't know, new one obey a friend Dominic, a bar shall know so when some days be quite notice or to try to be able to know. And I, former Attorney General, they means I bet to George say, near more a PIA dear, and shall I family of Democrat. Now, what they buffusem, I can send. I become near put a press conference in 18 or some say, Papa Dominic say, send some near my way away in now with my clear. NDC phone call who are buying port to moon, say, Mahama and Ndc, and then she say, Annie Ghana, baby, a corner there. Now, and because the president in him, situation way man. Now, say, Attorney General Tim sorry to me this near Madiana, and summer, say Ghana for, yes, near Canny, near Conning with former Attorney General. Anthony,
or pass judgment on the work of any of my predecessors in office, even though I was often at the receiving end of many unsavory remarks from sections of the populace, particularly personalities in the NDC. Since leaving office, I have also stayed clear of subjecting the work of my successor to any form of assessment, leaving that to discerning Ghanaians to do. Before this morning, I had made absolutely no statement or comment whatsoever about the conduct and performance of the new Attorney General. However, at the press conference, in a rather unconventional manner, he proceeded to malign the Attorney General and peddle the truth, half-truths, and misinformation, which is not only unfortunate, but the question as to the true motives and justification for his decisions. The judiciary was not crushed of the Attorney General. Some members were subjected to similar disparaging attacks under the guise of Dr. Ayeni's strained exercise for decisions she has taken as Attorney General. The attack on the judiciary to the stratagem of the NDC to blame others for their resolve long before losing power to clear appointees of any criminal liability for past acts by reporting criminal cases pending at Dr. Ayeni's decision of the resetting agenda of the NDC. The careful to bear this out. Dr. Ayeni was sworn in as Attorney General on Wednesday, 22nd January 2025. Friday, 24th January 2025, he caused to be filed a notice of abandonment and the state in Republic versus Atufosin and 2 others. On Tuesday, 20th January 2025, we withdrew the case against Dr. Sibnopuni and 2 others, resulting in the complete whitewash of their crimes by an acquittal and discharge through hardship. On 29 January 2025, we entered another withdrawal in Republic versus Atufosin and another, again resulting in an acquittal and discharge of the accused. 10 January 2025, Dr. Ayeni withdrew 2 different cases against Dr. Johnson Pandit Selma, resulting in his acquittal and in one and a discharge in the other. Entered by the NDC government through the Attorney General subsequent days. Indeed, hope be the kind of ladies and gentlemen, this involvement irresistibly to only one conclusion: a calculated, preconceived ploy on the part of the NDC to wipe out all criminal cases against its leading members and officials of the John Mahama government and clear them of wrongdoing not by the courts but through their Attorney General. Remarkably, there is no precedent for this kind of conduct in the Fourth Republic. Throughout the 2 8-year terms of the NPP government, no Attorney General appointed by either president President Akufo-Addo withdrew criminal charges in cases involving leading members of the NPP or senior members of the government. At the time the NPP assumed office in 2017, all the cases filed by the Mahama and Ndc government against some ministers of the Akufo government and other appointees have been contested fully in the court and won. We secured acquittals through the court by resorting to delay tactics in the hope that appointed Attorney General would come and withdraw the cases and procure an acquittal. I speak from experience as I personally conducted some of the cases. Other lawyers within our ranks, including my colleague Deputy Attorney General, also handled it. It is really unprecedented for an Attorney General to hold a press conference and subject his predecessor in office to abuses and peddle falsehood in the manner displayed by Dr. Dominic Ayine. I'm constrained to set the record straight, to unveil the half-interpretation of facts, to decipher the true intentions of the NDC government acting through the current Attorney General and withdrawing charges against leading members of the NDC. One, it is necessary to indicate at the outset that the decision to charge a person with a criminal offense, especially in the high-profile cases in issue, which have serious implications for the public interest, involved a prosecutorial discretion exercised pursuant to painstaking investigations conducted by duly authorized investigative authorities of state, inquiries and extended processes by career prosecutors in the office of the Attorney General, who indeed proceeded to conduct the cases themselves. I continue to be grateful for the advice I received from the hard-working attorneys at the AG's office, investigators and my able deputies, Mr. Cases we personally initiated in office, and the many others that have been commenced by my distinguished predecessor, Madame Gloria Akufo, which we continued. We cherish the robust discussions and debates we had whilst professionally moving forward with each of those cases. The nation would note that Dr. Ayine and other leading figures in the NDC and the government of the day were counsel in many of the cases he has discontinued. I say that indeed it is not uncommon for defense counsel as Dr. Ayine and other NDC personalities were looking at the same set of facts to come to different conclusions informed by their varying understandings of the law and, of course, the undeniable political considerations they hold. However, I dare say that in taking decisions as monumental as withdrawing those cases, the only consideration has to be in the national interest and not that of defense counsel. The analysis I make of the reasons advanced by Dr. Ayine will expose the questionable intent behind the withdrawal of the criminal cases. Dr. Ayine's unfounded allegation insinuating unethical conduct on my part in the conduct of the ambulance trial, Republic vs. Council 2000 and two others, is highly disingenuous and rather unfortunately recaps the series of falsehoods persistently published by foot soldiers of the NDC and other uninformed members of society. I must say that I find it quite ironical for Dr. Ayine, who is a subject of disciplinary proceedings for professional misconduct, still pending at the General Legal Council, filed by the Honorable former Chief Justice himself, to accuse me of unethical conduct. In the interest of the nation, the case of professional misconduct pending against Dr. Ayine and the General Legal Council should have been determined before the parliamentary assessment of his suitability or otherwise for the high office of the Attorney General and Minister for Justice of the Republic. The facts relating to allegations by Dr. Ayine that I interfered with an accused person in the ambulance case are well within the public domain and have been adumbrated in court proceedings. The record shows that there has been a judicial determination of that unfounded allegation frequently made by foot soldiers of the NDC and other uninformed people. Shockingly, Dr. Ayine, the current Attorney General, ignored this fundamental fact in his 10-page press statement and over an hour conference with the media for the simple reason that he knew that his allegation had been flatly debunked by the court when same was put to strict scrutiny. If you would recall, the accused person in the ambulance trial filed an application for mistrial, hanging same with alleged interference with one of the accused persons. On 6 June 2024, the High Court quorum or sitting through or presided over by Chief Justice Ifeanyi Sewaswa dismissed the application. You would all remember the learned Justice of the Court of Appeal, who sat as an additional High Court judge, said that she had listened to the tape in question about 10 times and found nothing to warrant a mistrial. Specifically, she stated at page 24 of her ruling, and I quote, "After listening to a conversation between the third accused and A1, the issue of whether the